Hello, everybody. No, I was in the shower. Go easy on me. I didn't even put my socks on. I just ran as quickly as I could to here. I've got the treats. If I can reach them, they're deep in that box. There we go. Ha! 3. The first grab. Oh. Hello, Nana Lorani. I love you. Hello, Jerry Matthew Boyd. Hello, Mortimer Duke. I know you're referring to Ava. Hello, C-Rex. I mean, we could always leg wrestle. I see that that's a thing now. Hello, Wire Mother. Hello, Buzzy Pug. Hello, Penny. I love you. Hello, Eileen and Carlin. That was your third one. That was your third one. That's the treats. That's the treats. Yep. She's so cute. She is so adorable. I just love that face. Hello, Charlie. All right, you guys. She does. She gets plenty, though. But she always could use more. She will pretend like she's, so neglected. No treats, no food, no kisses. I just make her sit there all day long. Don't pay her any attention. Never play with her. She's lying. Oh, we're going to have a good time tonight, guys, as usual. I know, but they do it with those eyes. Man, if I could give the puppy dog eyes, I bet you I could rule the world. It's just not the same. It doesn't have the same effect on people. I can't give puppy dog eyes. Oh, should I be scared? Uh-oh. Anytime it's squishy, I gotta worry. No. He did send me the short that he had made of our favorite love lady. He's like, aren't you following her? Sorry, but I had to make a short. I'm like, yes, but it's okay. You can have it. Oh, Insomniac chat. Let's see here. posted the link to the Furball Farm Cat Sanctuary. I don't think I'll ever get there. I don't think I'll ever get there, Squishy. This is what you guys get. I know. They sure do work for some things though. Which one of you is expecting? Who's the daddy? Well, it's neither one of those guys. They're working men. Hello, Squishy. No, Jerry just let me know that you posted an Insomniac chat for me, and then I checked it out and I saw the link to Furball Farm saying I had some catching up to do. I'll never get there. I will never get there. I'm not that rich. I've seen it. It's beautiful. I've seen it. I love it. I've never physically gone, of course. That would be a whole nother wild story. You know, you're periodically late. We're not even 10 minutes in, and I'm going to need my freaking inhaler from you guys. Oh my gosh. Oh man. Oh, it's so humid out. And I just got out of the shower, so now I'm all wet. It doesn't look right. Oh my gosh, I need to put my socks on, guys. I hate not having socks on my feet. Drives me crazy. So I'm going to add the kitty towers. I did order the lights for the dark tower. So I have them coming, and then you'll be able to see each level. Like almost every woman in every body cam video. Oh, for sure. It involves cats. You think that didn't pop up on my timeline? I think YouTube might have noticed a little trend with me. As in every daily dose of cats, and this cat is cute, and watch these cats play, and you know, I watch them all, and YouTube might have noticed a little because they keep giving me more and more. I kind of maybe like them a little bit. Oh, so let's put the cases on. Let's get something going for you guys to watch.
Mr. Barnett, Miss Vogel, can you hear me okay?
Yes, ma'am.
Yes.
This is file 260318 SM, People versus Vernon Lee Barnett. Mr. Barnett was convicted after a trial by jury to a charge of domestic violence. At that time, I requested a pre-sentence investigation be drafted, and that has been completed. So we are able to proceed to sentencing today. Ms. Vogel, have you had an opportunity to review the pre-sentence report with Mr. Barnett? If so, any additions, deletions, or corrections to it?
I have had the opportunity to review it with him, and we have nothing to add, Your Honor. Thank you.
Mr. Duffield, is Alyssa Nicole Freemeyer present, or has she submitted any type of impact statement to your office?
Thank you, Your Honor. I do not believe Ms. Freemeyer is present. We have not received it. Oh, she's on Zoom. Oh,
Yeah.
I would defer to her on Zoom. Let her make a statement. I was going to say she did speak at trial, but she should have the opportunity to speak today as well.
She does, and we're going to bring her in for that purpose. Ms. Freemeyer, can you hear me?
I sure can.
We need you to sit down, sit still there, so we can
Yeah.
get you in focus here. All right, once you're still, we'll get going here.
All right, I'm ready.
If you would please state your full name for our record.
Alyssa Nicole Freemeyer.
Ms. Freemeyer, this is your opportunity to tell me anything you would like to for Mr. Barnett's sentence this morning.
Well, like I said a little bit the last time I spoke, the issues that I've dealt with in my past, I feel terrible because I'm not a victim. Like to be honest, I feel like he is, and it's a really, really terrible feeling that he's sitting there because of me. And he's the only thing positive that I've ever had in my life. And it's devastating, to be honest with you. I am getting help through the mental health services for counseling and stuff to kind of help me and see if what can be done there for me. But I would be pleased if it were an option that the no contact order was lifted, so we could at least speak to each other. I don't really know what else to say other than that. I feel terrible. And I mean, yeah, I miss him and all that, but even if he were to never speak to me again after this happening, I'm a just person, and I feel like my state of mind, it kind of like snowballed. However, the mentality happens, but
You know what else is just? Our court system and someone being found guilty by a jury of their peers. Now, I don't know the facts of this case. I was very tempted to go back and find previous hearings, but unfortunately, I didn't have the time to do so by the time I did find this one. But I cannot believe, especially the way she's talking here, if he was so innocent, I can't believe he was found guilty by a jury. You can't claim corrupt judge on this one.
I care for him and love him enough that if he didn't ever talk to me again, I'd say I still would feel the same way.
Mr. Barnett, this is your chance as well to tell me anything you would like to for your sentencing this morning.
Yes, Your Honor. Since I've been in here, I've lost a lot. Not just my freedom, but I lost my child. My girlfriend was 6 months pregnant at the time, and we lost that, which is hard to find out. But since I've been in here, I'm in the God pod now, and I'm doing a lot better. I've continued my sobriety through Arbor Circle and On Point. Doing Bible study. You know, I'm trying my best to continue a positive life while I'm in here, and I just want to get back out and continue what I'm doing positively with my girlfriend and have a good life together. But that's all I got to say, guys.
Ms. Vogel, on behalf of Mr. Barnett for sentencing.
Thank you, Your Honor. Mr. Barnett has spoken with me about his past. I know you've mentioned his criminal history when we set this out for sentencing. We would like to note that most of his criminal history is from about 15 years ago when he was in his 20s and 30s. However, he did, of course, have an OWI about 8 years ago. And then about 3 years ago, he experienced some extreme trauma when he lost his nephew and his sister within 2 months of each other. His nephew actually had committed a suicide homicide, killing his partner and himself. This was a very traumatic loss, very traumatic situation. He was experiencing a lot of emotional pain, and he turned to drugs and alcohol. Since then, that has been something that is just kind of snowballed in his life. He's struggled with that substance use disorder. However, he has been working very hard in the jail. He's been incarcerated for a little over 2 months now, I believe, or a month and a half. And he's been working very hard to use all of the different programs available at the jail. He's been I apologize. He's been doing AA and NA as he studies in the God Pod. He's going to school. He's actually been enjoying carpentry. He's been enjoying a psychology class, and he's been enjoying learning more about the safety aspect of work sites. He's trained as a union carpenter. He's not able to do that anymore due to a back injury, but he's learning and growing in his abilities to work in other aspects of construction so that when he does get out, he'll be able to get a job and he'll be able to work in that. He will have a place to live when he gets out. He's also been working with Arbor Circle, going to Bible study, essentially taking full advantage of the services the jail provides to work on himself mentally, physically, and emotionally. Additionally, he helps take care of his 80-year-old parents. So we would appreciate the opportunity for him to work with them again. Finally, he is currently incarcerated on a jail term for his probation violation. We would be requesting a sentence that would allow him to get out at the same time that he gets out on that. He'll be there until September 14th. That is fairly extensive term of jail. We would request a concurrent sentence with that so that he be able to get out on September 14th on this as well, with no additional probation. We would also request that the no contact order be lifted based on the wishes of Ms. Freemeyer. Thank you, Your Honor.
Barnett, from where I sitting, you've been consistently involved in criminal behavior for years. Criminal history shows 4 prior felony convictions, 11 prior misdemeanor convictions, 2 prior assaultive convictions. As your attorney said, your criminal history goes way back, and you were still convicted again a few weeks ago. So nothing's really changed. This is now your 3rd assaultive conviction. The court file from the PSI shows you're serving a 330-day jail sentence on a totally unrelated matter. According to the jail roster, you can be released from jail on the 14th of September of this year. So you're going to be spending all summer and part of September within the system as is. So given all of that, the recommendation here, I think, is accurate, as not to place you on any probation, simply to impose a jail term of 30 days. And that will be with credit for 30 days you've already served in the Allegheny County Jail. Looks like you're going to be released again on the 14th of September. I can waive your I can waive your fine and cost. I cannot waive your state fee and your crime victim right fee. That's a total of $125. You'll need to make arrangements to pay that within 30 days of your release from jail, which would put this out until October 14th of 2026.
So he only gets 30 days, but he's still incarcerated for 5 more months. So, I mean, the judge could have, laid it on him with whatever the max penalty would have been. They never do that, of course. But he's already serving a sentence and he's not going to be out for a while. So I think they just said, we'll sweep this one under the rug and call it good. And yeah, that little pity party he was throwing, I mean, it would have been so easy to fall for that. Thank goodness the judge has his criminal history and can tell the truth.
You'll not be placed on probation. The case is concluded today, which means the no contact provision of your bail is canceled. Because bail is canceled, contact is going to be allowed. I guess it's going to be up to the jail staff to determine, but it won't be because of this case. So again, Mr. Barnett, the last piece of this is going to be payment of the state costs and crime victim right fee of $125 within 30 days of your release from jail, which would be out to October 14th of this year. Good luck to you, sir. Thank you, Ms. Fogel.
Thank you. God bless you. Thank you.
Rose Ayala, can you hear me okay?
Yes, ma'am.
This is file 254122SM. Here today for sentencing back on April 24th. You entered a plea of guilty to a charge of assault and battery. That was pursuant to
Yes,
an
sir.
agreement with the Allegheny County Prosecutor's Office at the time of your final settlement conference before a jury trial. In that written settlement conference form, the prosecutor's office agreed to make no specific sentence recommendation. They did ask that we set this out for sentencing for crime victim rights purposes. Mr. Duffield, is Kelly Balgoyan present today, or has she filed any type of impact statement?
Thank you, Your Honor. I do not believe she is present, but I do have an impact statement to read for the court.
Go ahead, sir.
Thank you. Regarding victim's personal reaction, she states, "I'm always scared now, feeling I have to watch my back. I walk everywhere and I'm afraid for my life that she'd run me down with her car. When it happened, she beat me so bad I didn't go out in public." Regarding victim's physical or emotional injury, she states she had vision issues from swelling, headaches, and pain in her face. Was seen by Lee Township EMS, but did not seek treatment afterwards as I could not afford it. I avoided public for quite a while as much as possible. I was scared and also embarrassed. She suffered no property loss and is not seeking any compensation. Regarding sentencing or disposition, she states that there should be no way this person is not punished with jail after this much abuse. She went crazy, and I do not feel it is safe in society without her receiving punishment as well as help with conflict management or therapy, and no contact with me for my own safety. Regarding other comments or concerns that she wishes to express, she mentioned that drug abuse is a huge part of the problem, active and frequently uses substances and was extremely addicted. She very well could be a completely different person without this problem, and elected to have this statement be read but not be present for sentencing. Thank you, Your Honor.
Ms. Ayala, this is your chance to tell me anything you would like to for sentencing as well.
Your Honor, I feel really bad. Let me get myself together real quick. This has taught me that not to put myself in these situations, to walk away. Your Honor, I'm really truly sorry, but I did not beat her as bad as she's saying I did. I only hit the lady one time, and that was because she kicked me in the stomach, Your Honor. I didn't know what else to do. I don't do drugs. The only thing I do is smoke pot. And I don't want to go to jail, Your Honor. I'm really, really sorry. I won't do it again. I didn't need to do it in the first place.
Ms.
I
Graber, on
have a
behalf of.
child.
Oh, gosh, you're done.
I'm sorry, sir. What did you say?
Can't understand you any longer, ma'am. Is there anything else you'd like to tell me for your sentencing?
I'm really sorry. And please don't put me in jail. I have a child.
Ms. Graber, on behalf of Ms. Ayala for sentencing.
When she says, I have a child, my brain just cuts to the clip in Les Mis. I'm a terrible person, I know. Please, sir, I have a child. That's all I can see in my head because I can't see her.
Thank you, Your Honor. As my client indicated during her plea, this altercation initially started with my client pulling the named victim's hair. There was a dispute regarding money and property. My client confronted her and did pull her hair, and that resulted in the named victim kicking my client, which then resulted in my client hitting her, and a fight ensued after that fact. It seemed tensions and emotions were very high at the moment. As I indicated, money was involved, and people tend to not think as rationally when money is exchanging hands and maybe they aren't receiving as much as they believe they are owed. My client, as she's indicated to the judge, to the court today, she is very emotional regarding this incident. She has been very remorseful that she resulted to any physical contact to initiate anything. She knows that she needs to walk away, and there are better ways to handle this. And I ask that the court take that into consideration. And regarding her sentencing, I think if the court is appropriate, a short term of probation would be necessary, would be appropriate. As I do understand the named victim does not want any contact with my client. Thank you.
Victim indicates in her impact statement that controlled substances are a factor for this defendant. That's confirmed by her history of methamphetamine convictions here in Allegan County. We'll be placing you on probation for a period of 6 months, and that will be with counseling services as directed, both for anger management and/or substance abuse. While on probation, you're not to possess or consume any alcohol, marijuana, or illegal controlled substances other than controlled substances prescribed to you by a medical professional. They will have the authority to check you for that here at the probation department, have you checked by the police at your home, or have you physically monitored if they believe that becomes necessary at any point while on probation. Another condition of probation will be no contact with Kelly Balgoyan until further order of the court, which means I would have to sign an amendment to your probation order to allow that. In the charge of assault and battery, the fine is $500, court costs $300, state costs and fees $125. There is a $180 oversight fee for that term of probation for a total of $1,105. Court file shows you released from the Allegan County Jail on a PR bond, so all of that is due, but you will have the entire time on probation to pay that amount on a monthly payment plan set up through our probation department. Our probation department is going to call you this morning to set up your probation order. What telephone number can they reach you at today?
269.
You are free to hang up from the court proceeding. Be available at that telephone number. Be expecting a telephone call at that number from our probation department shortly. Good luck to you, ma'am. Thank you, Ms. Graber.
Anybody hear me?
Yes, Judge, I can hear you.
Yes, no? Go
Yes.
away? What?
Yes,
What?
I missed the Coney today.
Everyone's talking. Can you not hear them?
No.
We're live. Can you not hear?
Check.
Oh, I know why.
This is So funny. Now you just heard her announce we're live, but the judge's audio wasn't active yet. So he has no idea that they're live yet.
You ignored me?
There you go.
Yeah, well, I'm usually more technologically oriented, but I'm not going to say anything, but I just got back from speaking to the local Republican women's. So if there's any Democrats in the crowd, that's okay.
Both of them?
I did not cast aspersions on anybody other than they wanted to hear about the district court and what we did. So they've been after me for about a year. So I told them. I don't think I told any stories about Ruben Pizzana or Mike Warner.
But Franklin?
Yeah, I did tell one about Franklin.
I knew there'd be one about Franklin.
Well, you know, and y'all don't care, but I'll tell you anyway, because we're here on this hearing. But I remember when I was serving with Kevin Hart, Lubbock, we were we co-chaired the Child Protection Court Advisory Group for the Office of Court Administration. And you being lawyers, you'll appreciate this. So we had meetings in the Supreme Court building at 10 o'clock on Monday morning. Well, back then there was no way to get to Austin from Amarillo by 10 o'clock on Monday morning unless you went down the night before. And so, but there was a direct flight from Lubbock. So I would drive down to Lubbock, spend the night with Kevin Hart and his wife, Michelle. And then Kevin and I would get up and we'd catch the red eye out of Lubbock Airport. So we walk into the concourse and there's Franklin McDonough. Mr. Pizzana, so you'll know Franklin McDonough's used to be the district judge. Used to be the district attorney, and he didn't beat me in the primary because I'm so old. The Constitution says, see ya, wouldn't want to be ya. We don't care, you're gone. So I couldn't run again. So he's going to be the new district judge beginning next January. So he's sitting there. And he's not a DA then, he's practicing law, and I had appointed him in a termination case over in Wellington. Well, he got back the Sunday before, so this is Monday morning early, 6:30, whatever. And he had gotten back from vacation the Sunday before, and he's going through his mail, and I said, you lawyers will appreciate this, because you've been there. And so he sees a letter from the Supreme Court. And this case is at that level, and they're asking him for a response. I forget what the action was, but and then said it's due by Monday, which was the Monday we were flying to Austin, right? And he's got this the day before, and they had suspended the mailbox rule. So he's got to figure out how to get from Pampa, Texas to Austin. And before that, he had to prepare a response. So he couldn't find any place to have it copied or anything except Kinko's. I think he finally found one in Amarillo, may have been Lubbock, I don't know. And so there he was. And so when we got off the plane in Austin, we're both going to the Supreme Court building. We're going to OCA's offices to have our meeting, and Franklin's going to the Supreme Court to file that. And so Judge Hart and I kindly consented to let him share our taxi. So one other time we took that red-eye flight, and Justice Phil Johnson was on the plane, and Judge Hart knew him from Lubbock, and so Justice Johnson gave us a ride to the Supreme Court building, which was nice, for a Supreme Court justice to do that. And so as we're on our way out to the parking lot, Judge Hart says to Justice Johnson, yes, all of the appellate judges know Phil. Talking about me. And I said, yeah, that's because I'm always affirmed.
You can say that with a straight face.
I could.
That's awesome.
Yeah, when of course, since then I've been reversed, and I still don't agree with him, but that's the way it goes.
What do they know?
Yeah, yeah. I'll tell you one more story, and then we got to get to work here. But there's a story of an appellate justice who was a real close friend of a trial judge, and so he had the habit of when the appellate court would rule on his cases, that his good friend would bring him a copy of the opinion. And so the appellate justice walks into the courtroom, and the trial judge is on the bench, and there's they're doing a docket call or something, so the place is full of lawyers and people, and so the appellate justice walks up to the bench. Have you heard this, Mike?
I have
And so
not.
he walks up to the bench, and he hands the opinion to the trial judge and turns around and walks out. Doesn't say a word, just hands it to him. And so the trial judge looks at this appellate court opinion and rips it in half and says, they can reverse me, but I don't have to like it.
That's awesome.
Only way you get away with that is, well, actually, the appellate justices are not all that bad. They're all right.
Yeah, I mean, how do you not get thrown in jail for that?
I don't know. Hopefully he's a good friend or something,
Something.
Yeah, that's that story. All right, Karen,
We're live.
okay. Has this been live the whole time?
Yes.
Oh, thank you.
You're welcome.
Great. That's just super. All right, this is the 223rd Judicial District Court in Fort Gray County, Texas, proceeding via Zoom.
Presiding. Now calling case numbers 26S00109, 26W000317, 26W000608, and 26W000756. These are the matters of Larry Donnell Hawkins III. Appearances for the record, please.
Hi, Larry Hawkins. How are
Good
you?
afternoon. Good afternoon, Your Honor. Assistant Public Defender Nicole Van Blarken within on behalf of Mr. Larry Hawkins.
All right, thank you. So we are here for an arraignment in the matter ending in 0109. And what I am seeing here is that a bench warrant issued for your arrest, Mr. Hawkins, after you failed to appear for a pretrial conference date set for you in front of Judge Washington on May 11th. So.
Yes, Your Honor. We would just reserve our bond argument for when that's appropriate.
You may address bond.
Your Honor, at this time, we would seek a personal recognizance bond for Mr. Hawkins. He was unable to come to his last hearing as he was in a psychiatric facility from May 9th to May 18th. He does have documentation of that, just not available to him while he is in the jail.
All right. So yes, we will need to have that documentation. So Mr. Hawkins, supply that to your public defender once you're out, okay?
I will have that submitted today. I will have that if I can get out soon. I can have it in by 2 o'clock. I just have to get to Detroit to get to my car. Your Honor.
Yes.
For the record, I have a lot of things that I need to talk about.
Mr. Hawkins, today would not be the day for that, okay?
Of course, it's just I'm letting the magistrate know so I can address this appropriately by email and be detailed and specific because I don't want all of this on the record.
Okay. And to be clear, as the magistrate, I won't be hearing your case. So you're going to have another court date in front of the judge.
Okay.
Okay. So that will be. Okay. That is going to be June 9th. That will be at 9 in the morning. That's in person at the 14B District Court in courtroom number 1. At this time, the court is reinstating the bond that was initially set by Magistrate Odetella. That was $1,000, 10%. That was posted by a third-party agency. So we already have it, basically. all of the conditions that were placed upon you are still in effect. None of that's changing. It does look like that you were ordered to have a GPS tether prior to release. Do you still have the tether?
So, guess what?
That's a yes or no question.
No, ma'am, because
Okay.
Mr. Brian Levitt has not made contact with me. He ordered to have it taken off while I was in the psychiatric facility in Battle Creek, Michigan.
Okay. So, when I say that all of your conditions are being continued, I do also mean the GPS tether. So I am making a note here for the GPS tether prior to release. All right.
Brian Levitt would have to be contacted immediately because he would have that.
Mr. Hawkins, the jail can get that for you.
Yes. All right. So, then you've got your next court date again. That's June 9th, 2026, 9 in the morning. That's in front of Judge Washington. The other 3 matters that I called were civil infraction citations. So, you have balances in these. It looks like your total balance among the 3 of them is $560.
Okay, I would have to go on a payment plan for that.
Okay, and that's something that you can discuss with the judge as well. All right. So you'll have,
Your Honor, I do have a question.
yes.
So, how do I? Okay, so it's court dated paperwork. It's court mandated paperwork out of another county, given my mental health conditions, prompting my psychological release from the institution. So,
Okay. This
I am.
sounds like you should probably have a conversation with the public defender about this. All right. So I don't know how much of
Because
your business you want on the record. Anything that you say to me right now is on the record.
I know.
Okay.
What I'm saying is that prompting my release from the psychiatric institution, how am I supposed to continue the conditions of the agreements I have set in place with them if I'm tethered to that address?
Mr. Hawkins, you can give our office a call, and I will be contacting Ms. Davies as well. So she should be able to reach out to you, and she'll be able to answer those questions.
Did you still reach out to CMH?
I have reached out to my office to see if we can reach out to CMH. Okay.
Okay. And then, yes, obviously, if anything is conflicting between jurisdictions, then Attorney Van Blarkum, someone from your office, or Mr. Hawkins' appointed counsel should let the court know. So
Yeah, and then
basically what I'm asking is that are you able to put a hold on the tether restrictions until what's today? Wednesday? Today's Wednesday.
Yes.
Okay. Tomorrow afternoon, because that way I would have everything set in place to have full communication with the facility and their terms, and especially the court that should be handling this, which I'm assuming is Ingham still.
Okay. Have a conversation with your attorney. All right. At the moment, the conditions are what they are. If they need to change, then your attorney can file a motion. You've got your next court date. This hearing is concluded. You're free to go to the door and tell the jail that you're finished.
Okay.
Thank you.
All right. Good morning, everyone. Before we begin, I want to tell you that Ms. Rayford is the official court reporter for this court. She's taking down everything that's being said, and she is making the only official record of these proceedings. The Texas Constitution requires that courts be open to the public. In an effort to comply with that requirement, we're also live streaming on YouTube channel Judge Jeff Duran. Because we are live streaming to the public, please don't give out any specific identifying information like street addresses, email addresses, telephone numbers, or full names of children. First up this morning is CCL 2217758, in the interest of the Morrow child. And I see that we've got Mr. Nicholson, and I believe, yeah, there's Andrew Morrow, and I think the mom, Miss Brown, is on as well.
Yes, I am.
Okay, and Mr. Morrow, will you engage your video capability, please, sir? All right, and will each of you please raise your right hand? Do you and each of you solemnly swear or affirm testimony you shall give in the cause now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Very well. Mr. Morrison.
Yes, good morning. This is Scott Morrison from the Attorney General's office. And the judge, we have a motion to enforce before the court. Mr. Nicholson has been appointed to represent Mr. Murrow, and Ms. Brown, I believe, is here pro se, and the state is ready to proceed.
Very well, Mr. Nicholson.
We are present, ready. I'm getting an echo for some reason.
Yeah, you've got two
Well, how about
ways.
it? Well, I was having trouble getting it to log in.
Well, you've still got another one going here. What I'm going to do is I'm going to move that one to the, well, I can remove it.
Well, I'll see if I can move it from my end.
Well, I can do it.
There we go.
Okay.
There we go. No more
Yeah.
echo.
Yeah, no more echo.
We are present. I will tell the AG my client is employed now. I don't think a wage withholding order has been issued yet, but he has an employer that one can be issued to.
Okay. And maybe we can get some of that information during the testimony. And then if I know, just this is a side note from the motion, but if he can provide us wages, I know he's requested us to look at his child support obligation, the ongoing one. And if he can provide us his wage information, then we can review that. So
I've already explained that to him as well.
alrighty. I will, I guess, Judge, I guess I'd go ahead and start then. First, I'd ask the court to take judicial notice of the prior orders in the court, specifically the order signed in September of 2022, ordering Mr. Murrow to pay child support.
So noted.
And then I've also, there was a financial activity report that was attached to our motion when we filed it, but I've got an updated financial activity report reflecting some recent payments, and I'd like to introduce that updated pay record into the court.
Mr. Nicholson, any objection?
I've already received that by email from the AG's office. I have no objection. I will note that my client tells me he's made one additional payment that's not reflected of $50. That's not reflected on that. I guess it just hasn't got processed yet.
Yeah.
Very well. Without objection, the exhibit is admitted.
And first, I think I'll call Mrs. Brown.
Yes.
Okay, Ms. Brown, would you please state your name?
Mercedes Brown.
And you are the obligee, the person entitled to receive support in this case. Is that accurate?
Yes.
Yeah. And the child, how old is the child involved in the case?
7.
And does that child live with you?
Yes.
Okay. And is it accurate that, according to our pay record, you did not receive any support from the date of the order until some payments were made in April of this year?
Correct.
Okay. And is this support important to your household in helping to furnish the child with what it needs?
You asking, is it important?
Yes.
You talking about the payments?
Yes.
Yes.
And is it important for you to receive regular child support payments to help maintain the child's household?
Yes.
Okay. the state is going to be recommending,
Hold on.
I'm going to be recommending a finding of contempt and a probation order, not to where Mr. Andrew is not put in jail, but placed on community supervision to pay support. Do you have any objection, or do you have a thought on that recommendation?
No.
Okay. All right. And if I believe, to make sure it's accurate, you received, it looks like there was $150 paid in April. And then there was $100 paid in May voluntarily. It sounds like Mr. Morrow has sent in another payment that hasn't posted yet. And then a cash bond was applied, which you received. It looks like $975 of that cash bond. Is that correct?
Yes.
All right. I will pass the witness.
Mr. Nicholson?
And you understand the other $25 on that cash bond went to the state for medical. And you correct, Ms. Brown?
Well, I mean, I wasn't aware of that, but I was okay.
Okay. And all right, I'll pass the witness.
Mr. Morrison?
Have anything further of this witness? May have some questions of Mr. Murrow on cross if he testifies.
Very well. Mr. Nicholson?
Yeah. Call my client, Andrew Morrow.
Yeah.
Hey, Mr. Morrow, are you employed now?
Yes, sir.
Where are you employed at?
At Ava Nursing Home.
What nursing home?
Ava.
How do you spell that?
Ava. A-V. Hold on. It's called a Veer at Town Creek.
Oh, Avere at Town Creek.
Yes, sir.
And how do you spell Avere?
A-V-I-R.
Okay. That's here in Palestine.
Yes, sir.
You think the court, you said you want if he has the address, do you want him to do that on this live stream, or would you rather him just get it to the AG?
Just get it to the AG.
Okay. And how long you been working there?
Since March.
Since shortly after you got out of jail?
Yeah.
On the cash bond?
Yes, sir.
Okay. And how much you making working there?
12.
$12 an hour? Is that correct?
Sorry?
$12 an hour? Can you not hear me?
Yeah, your phone it's breaking up.
Yeah, I think everybody else can hear me, right? Is it on my end or is it on his end?
I think it's on his.
I can hear you now.
Huh?
I think it's on your witness's end.
Okay. $12 an hour?
Yes, sir.
And how many hours a week are you working? He seems to have frozen up, Judge.
Yeah.
Now he's disconnected entirely. It looks like.
Well, he's still on.
No, there he came back. Mr. Morrow?
Yes, sir.
How many hours a week are you working?
Like 35.
Okay. Do you have any benefits? Do you have any health insurance or anything available through your employment?
No.
Okay. Are you willing to be placed on probation for this? That we're talking about like a non-reporting probation. You wouldn't have to report to the probation office or do any community service or anything like that, or pay a probation fee. They would be monitoring to make sure you were continuing to make child support payments. And if you don't, they could file a motion to revoke probation and try to put you back in jail. But that'd be up to the judge to decide at that time.
All right.
Okay, and you understand the AG will likely be issuing a wage withholding order to start taking child support payments out of your paycheck.
Yeah.
Also, they've indicated they are willing to consider modification, but you have to get them documentation on exactly what you're, I know you just testified what it is, but they're going to need documentation on all that from you.
That's fine.
All right. And they're also going to need you to provide them with the address for your employer where they need to, who they need to notify on the wage withholding. Okay. Not right now, but get that to them. Or if you can't get it to them, bring it to me and I'll get it to them.
Yeah. Okay.
All right. I'll pass the witness.
Mr. Morrison.
Yes, thank you. Just a few questions. Mr. Murrow, you said you were working at ABL Nursing Home. Is that
No.
true?
AVIR.
ABIO?
No, V is in Victor. AV.
IO, AVO Nursing Home?
R, I believe. Isn't it?
AVIR.
Yeah.
Okay.
A is in
And-
apple, V is in Victor, I is in icicle, R is in robot.
Okay. And that nursing home's located in Palestine, is that correct?
Yes.
And do you work directly for the nursing home? The reason I'm asking is for wage withholding purposes.
I work
Directly for them? Okay. And we're going to try to send out what's called an automatic withholding order. We can do that administratively. We're going to try to do that. And let me ask you this. Besides this child, how many children, biological children, do you have?
5.
Okay. So we have the child before the court. You have 5 other children. Did those 5 other children live with you or other people?
3 of them do. The other 2 don't.
Okay. And the other 2, are there actually child support orders for them?
Yes.
So it is possible when a wage withholding goes out that they apply money to each case. Okay. That you have an obligation. I don't know that, but that could happen. So you're aware. Do you have the ability for any other employment other than the $12 an hour?
No.
Okay. All right. I'll pass the witness, Judge.
Mr. Nicholson.
The 3 children that are living with you, how old are they?
1, 4, and 7.
Okay. So they're all younger than this child that's subject of this case?
Yeah.
Okay.
But 1, yeah.
Okay. And the other 2 that you have child support obligations, are those out of Texas or are those out of another state?
It's out of Texas.
Okay. So those you have AGK, are those in this county or another county? The cases on those?
Another county.
Huh?
Another county.
Another county. Okay. All right. I'll pass the witness.
Mr. Morrison.
That's all I have, Judge. Just argument, I guess.
Very well, go ahead.
Judge, I would ask that Mr. Murrow be found in contempt on past months where he did not pay child support. That'd be months preceding the date that he's paid some child support and not including dates that he was incarcerated on this. I would ask for a judgment. I would ask for the judgment as of yesterday based on the pay record. And the reason I would do it yesterday is because there sounds like there's some money on the way. And so we want to make sure he gets credit for that when that comes in. We'd ask for a judgment of $33,046.79 on child support.
I'm sorry, what is the number?
33,046.79
Okay.
on child support, and a judgment of $1,182.73 on medical support. It is a high arrears. I am going to ask that this case be referred for a modification based on the number of children he has and his wage rate. So that could adjust. I believe we probably need, even though he owes a lot of money, we do need to keep the amount to pay back on the judgment fairly small based on the wage situation. But he does owe quite a bit. I would ask for an extra $100 a month on the child support judgment and an extra $25 a month on the medical support judgment. And a finding of contempt and be placed on community supervision, non-reporting, with just requirements that he pay his support and pay arrears as ordered. And I'll defer to Mr. Nicholson on any other request.
Mr. Nicholson?
Yes, Judge. I think we're in agreement with most of that. The ADs will indicate they're willing to consider a modification, which he has asked for. He is willing to accept probation on this as long as it's the non-reporting. I think everything's in order. I'd ask that the judgment be granted and he be placed on this non-reporting probation. I'm only appointed on the case because it was a contempt action, Judge, for criminal purposes. So I'd ask that I be discharged from the cases. I would want any money to be going to the kids, not to paying more attorney fees for me. That he be placed on probation. And he doesn't pay, he can always come back to court, and if he's looking at going back to jail, somebody can be appointed again.
I don't really like the idea that if you have multiple children with multiple women, that you can get your child support reduced based on the number of children that you have brought into this world. That just doesn't seem right. But I'm also really appalled at the women that know they have multiple children with multiple women and choose to bed down with them and create more. Ma'am, if he's not taking care of his other 4, what makes you think that you're the lucky one?
And Judge, I guess one other request, I guess, would be the length of community supervision. I would ask for an amount not less than 5 years and not more than 10 years, depending on how the court would like to do it.
Whatever the court deems appropriate on that, Judge. My client's still here?
Go ahead.
Yes.
Don't see his picture.
Who are you looking for?
My client, I don't see his picture on my
He's
screen.
here. He's
Okay.
on.
Oh, there it is. For some reason it went off my screen.
All right, I find the court has jurisdiction in this case. I'll find the stipulated counts of contempt and sentence the respondent to 6 months. Sentences to run concurrently on each count of contempt. However, I'll suspend the jail sentence and place the respondent father on unsupervised probation for a period of 5 years. I find a child support arrearage of $33,046.79 and enter judgment for that amount. Order that paid at $100 per month. I find a medical support.
That's just in this case. That's not including his other cases with his other baby mamas. Sir, please. Please bag it next time. For the love of God, please.
Arrearage of $1,182.73. I'll enter judgment for that amount and order that paid at $25 per month. And Mr. Nicholson is finally discharged from the case. And I'll sign the order when it's submitted.
Thank you. And Mr. Nicholson, I will, I'll send you a proposed order so that you can review it before we submit it. if you would like, as soon as we're able to draft that.
Okay.
All righty.
You have any questions, Mr. Moore, before we go?
No.
Okay.
And that puts us in recess until 10 o'clock.
That's just icky. That's just icky.
Thank you, Mr. Nicholson. Thank you, Ms. Brown, Mr. Murrow.
All right. Good morning, everyone. Before we begin, I want to tell you that Miss Rayford is the official court reporter for this court. She's taking down everything that's being said, and she is making the only official record of these proceedings. The Texas Constitution requires that courts be open to the public. In an effort to comply with that requirement, we're also live streaming on YouTube channel Judge Jeff Duran. Because we are live streaming to the public, please don't give out any specific identifying information like street addresses, email addresses, telephone numbers, or full names of children. And first is DCCV 20-1774-349 in the interest of JTM. And I see that we have Mr. Moore and Ms. Kennedy on. And let me ask each of you please to raise your right hand. Do you and each of you solemnly swear or affirm testimony you shall give in the cause now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very well. Mr. Morrison.
Yes, good morning, Kennedy and Mr. Moore. Judge, what this is a petition for a non-agreed child support review order, making some adjustments to the obligations. To give the court kind of a roadmap and the parties, there's currently a child support obligation of Mr. Moore to pay $480 a month in child support,
right?
$192 in medical support. I believe there's been some adjustments in the cost of the medical support. I believe mother may carry the medical support. The proposed order, based on the information we've received, I believe, during a negotiation session with Mr. Moore, is it wouldn't actually adjust the child support too much. It would the cash medical, which I believe would include both health insurance and dental insurance. The proposal is for that to go up from just $192 to $229 a month. And then the child support, if you ran the new numbers based on that adjustment and the credits given for it, the child support would just go up $7 to $487, at least on the guideline information we had when they prepared this. We have also presented the court with a seek admission of a financial pay record because our order does contemplate seeking some judgments on child support owed and medical support owed, and seeking an arrearage payment on those, as if there is not currently a court-ordered arrearage amount.
Very well.
Mr. Moore, just an opening, Mr. Moore did ask for this hearing, although I may need to ask him why, because he put in their child custody agreement as the reason. So I don't know. I'll have to ask him some questions on what about the order he's disputing. So that's my opening.
Very well. And I'm going to ask the parties please to unmute yourself. I'm going to, there you go. Okay, Mr. Morrison.
Yes, I'm going to ask each of y'all some questions. I'm going to do it one at a time. And that's so the court reporter can, hopefully we don't talk over each other and in those type of situations. And each party will have an opportunity to say what they need to say, hopefully. So I'm going to start with Mr. Moore. Mr. Moore, would you please state your name?
Brett Moore.
And Mr. Moore, you did ask for this hearing, and it just said child custody agreement on the paperwork. What about the order were you objecting to?
Well, I haven't seen the kid in like 4 years. My fault, mom's fault, point the finger wherever. And I really don't have, I don't see in the future that I'm going to be seeing the kid anytime soon, if ever. So I'm trying to voluntarily relinquish my rights to the child. Just because we don't have a relationship. We're not involved with each other. Like he has his own life 8 hours away. I have my life 8 hours away. And I don't see how we can come to an agreement here to where we make it make sense. Like there's no way, I don't think.
I guess let me address a couple of things. One is, as far as what you're talking about is terminating parental rights. That's something you would probably want to speak with counsel on, as there's a procedure for that, and there's quite a bit involved with that. It's not something, and even if somebody can sign what's called a voluntary relinquishment, that's no guarantee it's going to happen. It still has to go through some court proceedings.
Okay.
Determinations need to be made, and some different aspects of that. So that's not something I can help you with. That's something, or the AG can help you with. That's something you really would need to discuss with counsel on something like that. As far as the court order itself, it was based on information you provided. Do you have any objection to the amounts or what we're proposing to the court?
Yeah. I believe it was calculated on my old income, and I don't make the same amount as I used to.
Where are you working now?
Orkin Pest Control.
Okay. And the information I have is it was based on the Orkin. And at least on at least the pay stubs we have that you provided, and we do appreciate it, in our I guess what I call our file, I guess is the best way to say it.
Okay.
Let me go over to it just to verify it. But and I know it, as for Orkin, you probably make a certain amount on it based on different factors such as sales and work and that kind of thing. Is that right?
Correct.
Okay. And in essence, at least my understanding is there is in our file. Let me get here. They did have. It's as of. Looks like it was provided to us shortly before this case was filed, but it was from Orkin. It was related to your payday. There's like a pay period from 3/22/26 to 4/4/26.
Yes, sir. 2 weeks. Yeah.
And so my guess is that they were using that, and probably used a year-to-date calculation on that.
Okay.
And so, I mean, I don't know what to tell you. It goes up very little on that, the proposal based on the guidelines.
Right. $7. But
yeah,
$7. No, whatever.
Yeah, normally we would not even file a modification on that, but I believe there was a medical adjustment for cost of health insurance.
Okay.
That's caused us to recalculate it. Now, the part of the proposed order that would, I guess I'm going to say more significantly affect you financially would be the ordered payout on the arrears.
Okay.
They may withhold some on arrears right now. I don't know. They have that ability, but it would have a court-ordered amount based on the amount, and that's where it goes up. It goes up a little bit also on the medical support, although it seems to be fairly reasonable on the amount that Miss Kennedy has. The medical support would go up to $229 based on our calculations on how we do these things, from $192. And so the proposed order would go up $7 on child support, and I guess 37 on medical support. The part that would more impact you financially is that there would be a court order to also pay back $100 a month on the child support balance. That's the back support. And 84 on the medical support balance.
Okay.
So I don't know if you have a disagreement with those numbers.
What am I paying in arrears currently?
You do not have a court ordered amount.
Okay, but yeah, but it's
sometimes
getting
they
paid, but it's not a court ordered amount.
Right. And I don't know if I'm able to actually even determine that, but let me see if I'm able to. Because the amount withheld, it's hard for me to determine that because the amount withheld, it varies from paycheck to paycheck, probably because of the way you're paid. You know, I'm paid a certain salary, so I know exactly how much the paycheck's going to be every week. Yours, just based on the amounts, it's a different amount, probably depending, because you're paid as Orkin, you're probably paid a different amount each week.
Correct.
That's my guess. So I don't know how much they're applying. But Judge, we are applying his to his case, and there is money that is being applied to arrears. It just varies. There's probably a formula. But we're seeking actually a court ordered amount to where it would be an ordered amount per month on that. So, but I hope that explains something to what we're seeking. So.
And what's the judgment amount on the child support and medical support arrears?
The proposed judgment amount on child support, and this was as of March 31st, was $11,258.10. And we're seeking a payout of $100 a month on that to help reduce that. And then a medical support judgment of $6,639.37, also as of March 31st, and seeking an $84 payout on that. The order does have a rollover, to meaning that if there's still money owed after this child support obligation ends, it just rolls to the amount of that plus the current child support to get paid off. So, but I believe the child is still pretty young child, so that we may have some modifications still in the future. It looks like the child is only maybe 6 years of age, if I'm guessing. So the obligation, and unless it was ever terminated, it's still going to be there for quite a while. So that's what we're proposing. And Mr. Moore, I don't know what's your viewpoint on that, or if you have a different proposal.
So we're going to increase the child support, increase the medical, and increase the arrear payments.
I can calculate
$30.
Yeah, I can calculate I can calculate if the court did approve the order, what the obligation would be each month. I could probably do it that way for you. So that's the way. Yes, believe me, I know. So the total current support obligation, both child support and medical support, would be $716 a month. That's including both of them. $487 on child support, $229 on the cash medical, which I believe is reimbursing for not only cash medical premiums but also the dental, I believe.
Okay.
And they just put it as one. Plus, if you added 100 on the child support arrears, that would be $816 plus 84. It's a 900 flat on at least what would be the court-ordered financial obligation. And are you paid weekly?
Every other week.
Every other week? So,
Yeah.
So.
And is.
Go ahead.
I'm paying child support on a second child as well. Does that have a credit involved with there, or like, because that would be like 1,500. No, it would be like, if it's 900, it'd be like 1,400 every 2 weeks.
Yeah,
And I can't pay that. We'll just get further back in arrears because I just can't pay that.
Yeah,
that just does not make sense.
The child support amount, guideline amount, the 487 was based on one child before the court and having one other obligation.
Okay.
So it's not a dollar for dollar credit. It's just that.
Right.
Sometimes if a person, does the other child live in your household or with somebody else?
With his mom.
Do you have any children in your own household?
No, sir.
Okay.
Anybody shocked by that? Who are these women that keep letting this man impregnate them? They need a checkup from the neck up, seriously.
So in essence, you can see the quandary you can get in when you have obligations in multiple households. I can't solve that for you other than propose the guidelines. So, but you can make a different proposal to the court if you'd like on the arrears, but it is a guideline amount. So.
Yeah.
Oh, I'm gonna pass the witness right now, Judge.
Very well. Your next witness.
Come back to Mr. Moore. Miss Kennedy, would you please state your name?
Caitlin Kennedy.
And Caitlin, you participated in the negotiation session for this proposed order, is that correct?
Yes.
And you were agreeable to this order, is that correct?
Yes.
Okay. And is there anything additional that you feel the court needs to be aware of? This is basically based on the information you provided regarding healthcare, the information we had regarding earnings, and the arrears. But do you have any additional information to provide or anything you believe the court needs to be aware of?
No, sir. I don't believe so.
Okay. I'll pass this witness, Judge.
Very well. Your next witness.
Mr. Moore, just kind of the same question. Do you, I guess you can, if you have anything you believe the court needs to be aware of, you may have made those points as well already, but any additional information or anything else you're requesting?
No, sir.
All right, I find the court has jurisdiction in this case. I find that there's one child, the subject of this proceeding, that the best interest of the child be served by entering a judgment modifying the current orders to provide that current child support is set at $487 per month, medical support reimbursement at $229 per month. I'll find a child support arrearage of $11,258.10. Enter judgment for that amount, order that paid at $100 per month. Find a medical support arrearage of $6,639.37. Enter judgment for that amount, order that paid at $84 per month. And I'll sign the order when it's submitted.
All right. I do appreciate it. And so both parties know, since we do have an open case, if situation does change on the information, it can't always be modified, but we can look at that to see if it can be. Okay. Glad to do that.
All right. Good luck to you folks. You're free to go or stay as you choose.
Thank you.
Thank you.
And CCL 1314047, in the interest of the McMorris Hatton child.
Yes, Judge, this is Scott Morrison here on behalf of the state of Texas
And I see Mr. McMorris. Is Miss Hatton on the call? I'm sorry.
She's not on the call. No, sir.
All right. Judge, I don't believe she has joined us. The state is ready to proceed, though. I believe we can.
You told last time we was on court, I think it was in February or more. You told her she didn't have to join us this go around.
It is an enforcement judge, so she may have elected not to appear.
Okay. Okay, and Mr. McMorris, will you please raise your right hand? Do you solemnly swear or affirm testimony you shall give in the cause now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Right.
Okay. Mr. Morrison.
Yes.
Yeah. Judge, this is a enforcement action. We did meet in February. The court did not do a final order at that time. The court did order that there be a lump sum paid and that child support be paid each month. We did receive the lump sum. It was a $1,500. We've received payments in April, but I believe the evidence is going to show that there was not any child support payments paid in March, nor yet in May.
I just paid that yesterday.
Okay. There was no payments paid in March. So basically, because of that and the arrears, I'm going to be seeking contempt filing. I'm not going to be seeking jail. I am going to be seeking probation. I think Mr.
Can I have a question?
We may want to yes, advise him of his rights, since I am going to be seeking contempt.
Mr. McMorris, let me ask you.
I had paid that $320 yesterday. I don't know why it ain't showing on y'all system. And on the reason why I skipped March, I had paid that $1,500, and he was with me. And then I don't know why his mom ain't told y'all, so she supposed to give me credit for more. But in April I did, and this month I just did yesterday.
And Mr. McMorris, are you operating a motor vehicle right now?
I had yes, sir. I had went and dropped my son off at the workouts. They out of school.
Okay, well, I want to advise you that talking on the phone and driving a car is illegal.
Yes, sir. I just pulled over.
Okay, good deal.
Sir.
The next thing I want to tell you about, Mr. Morrison has told me that he's seeking contempt, but he's not seeking jail time. And so
Yes,
I want
sir.
to tell you in connection with that you have the right to be represented by an attorney. If you're unable to afford an attorney and qualify, one will be appointed for you. You have the right to remain silent. You don't have to speak to me or Mr. Morrison or anyone else about your case. If you do say something, what you say will be used against you as evidence. Do you understand these rights?
Yes, sir.
Do you have any questions about them?
Yes, sir. I do have plenty of questions. I don't think that's fair about me being on probation, because I do what I'm supposed to do with my child, and the only reason why that month of March was skipped just because I paid that lump sum of money, and I don't know why she didn't call y'all March supposed to give me credit for that. And this month right here, I paid that yesterday, so I can show you that on my with my papers and stuff. You know what I'm saying? I got it in my car. And I don't feel like I don't feel that probation is fair. I ain't never been in no trouble. I ain't never been on probation. I don't think that's fair, because I handle my business. I'm not no deadbeat judge. I do what he with me now. I don't feel like that's fair. I feel like I should be on no probation.
Wait, he's with you now while you were driving on a Zoom call in court. That would be child endangerment. I don't think, sir, I don't think you're thinking your words through.
Because of that, I did the lump sum. I summed the 1,500. The month of March, he was with me. I don't know why she didn't call out to give me credit. April, I summed it. This month, I summed the payment. And I take care of. I'm not no deadbeat son. I'm not no deadbeat, Your Honor. I take care of him. He always with me. I take him to school, doctors, all that. So I just don't feel like that probation is fair to me.
Mr. Morrison, you want to reset this to give you an opportunity to look at the record and see if it's caught up?
Sure. I think, of course, I had no information that the child was with him in March, but
Right.
basically,
We're going to have to get the mom on too.
yeah,
I remember when last time we was on the phone, you had told her because she asked you, she had asked you, did she needs to be online? You told her no. So that's why she probably ain't online.
That's all right. It's not a big problem. We're just going to reset it.
And Judge, I think obviously if he made a payment, and the reason is Mr. McMorris, I'm not doubting you didn't send a payment in yesterday, but it takes a while to post to the account and be distributed. And so you would probably, if you do have an upcoming hearing for that month, it might be best to have that forwarded before that date.
It's on the receipt.
I'm not doubting you, sir.
Okay.
It won't post yet. I'm not disputing what you're saying, and I think maybe if you can make those payments between those months, maybe we can reach another agreement. I just had a month that wasn't. So
yes, sir. And plus, since and I can send it to you, Your Honor. Since they're in camps, I sent my son to camps. He got a camp coming up in 2 weeks. We doing all this training stuff. I just feel like I shouldn't be on that, Your Honor. And if you can reschedule it, and I sure appreciate that because I'm not no deadbeat.
Okay. Judge, would you like me to provide a date and that'll to give him time to keep child support payments coming and that kind of thing?
Yeah, let's set a date to come back together.
Okay. How about the late July date? And that will give him an opportunity for the May obligation to post, him to pay the June obligation, and him to have the July obligation paid as well.
Very well.
How about July 29th? Let's just say 10 a.m., if that's agreeable.
It's agreeable.
And Mr. McMorris, if you'll tell Miss Hatton that she should be here as well for that call.
Okay.
Okay, anything else?
No, I'd just like to make sure Mr. McMorris is ordered back on that date so that I don't have to reserve him. And
sure.
Yeah.
Mr. McMorris, and let me get your full name, please.
Jermaine McMorris.
Thank you, Mr. McMorris. And let me ask you to raise your right hand, please. Do you solemnly swear or affirm testimony you shall give in the cause now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. McMorris? I think he's frozen now.
Yes, sir.
Okay, and sir, this matter this matter is reset to July 29th, 2026 at 10 o'clock a.m., and that'll be by Zoom. You may or may not get additional notice of your obligation to appear. Even if you don't, my telling you now is sufficient notice to require you to be present, to cause a process to issue for your arrest if you're not present, and also to allow the case to go on in your absence. Do you understand what I've told you?
Yes, sir, I understand.
Okay, do you have any questions, sir?
I know that's about it.
Okay, we'll see you on July 29th.
Okay.
Thank you, sir.
Okay.
Yes, sir, that's correct.
Okay, Mr. Hamel, you're here on a bench warrant appearance. Looks like you failed to comply with, I'm going to guess, bond. What's the state looking to do? This case 24 CR 37. Set it for a bond revocation hearing?
Yes, Your Honor. He failed to appear at his last status conference, and so I think that's why the bench warrant was issued.
Okay, so it probably needs to be set for status then. So we'll set it for a status and bond revocation. Is there a date we can put on it, Brandon, or do you want us just to keep it blank?
He currently doesn't have an attorney. I don't know. He did sign a waiver back in December of 25.
Okay. Listen, Mr. Hamel, you have a right to an attorney on this. It's going to be set for a bond revocation hearing. The state's going to argue to revoke your bond, have you stay in jail until your case is resolved. Your attorney could argue to reinstate your bond. You plan on hiring an attorney, or are you looking for court-appointed attorney, or what's your plans with attorneys?
Sir, I have the paperwork needed that to finish the case. It was just needed to be notarized, and unfortunately, I wasn't able. My daughter, I wasn't able to come to get back in contact with her to have it notarized. But I have the statement written from her saying that she wasn't there when this supposed alleged violation of a PFA occurred, and so therefore, I just.
You have a no contact order with your daughter, and you contacted her?
No, there's no contact order. That's already been lifted. So this is all, she's been at my house and she's actually lived with me. And this has all been, resolved years ago. It's just, I just couldn't get it notarized, and she, and they've been through enough, you know, and I didn't, with schooling and everything. Yeah, Mr. Becker knows, the situation, I believe.
I'm concerned. I get that you have it notarized, but has it gone through the courts yet to lift it?
So that's, and I was just waiting to get that done. And on the court date that I missed, I don't have a vehicle or a license, but my Uber had showed up several times to take me to the hearings before and canceled that day. So I didn't have a way, and I do apologize. I mean, no disrespect, but I'm currently not doing the best medically, and I'm in a, you know, I'm kind of making a mess of myself here at the jail. And if I could just go home, I sure appreciate it. I have that letter. I just gotta get it notarized and have this all taken care of behind me, so I can be back to being a parent. And you know, I don't mean no disrespect, but I do apologize for what it's worth. As far as the attorney goes, I was just gonna say I was under the impression that once this is notarized, it would be taken care of. So I never have pursued that. And like I said, I have the paperwork. I just haven't had it been able to get her with me, or that because her mother's, you know, it's a complicated situation, and I, you know, it's the kids are the ones that suffer through that, and I'm just trying to
Okay, I'm going to keep you in there until your status date. It'll get set here within the next couple of weeks, I think. I think we just had status dates yesterday, so poor timing, but that's kind of how it goes. So anything else from the state?
Judge?
No, Your Honor.
Yeah.
We could do the 19th of June, or 6th of June. The 2nd's pretty full.
Well, I'll let you and county attorney set that. But yeah,
we probably could special set it with the bond revocation sooner than the 19th.
Yeah, let's do that. All right. Anything else?
I guess there wasn't anything else. Oh, snitch off to be a menace again? Thanks for stopping by, buddy. felony court hearings, Charlie? Yeah. I somehow I don't buy that. Oh, Charlie's funny. He's in love with a convict I've regularly featured on here. At least he thinks he is. That is so exciting, Spider-Man. I'm so happy it went well for you. That's amazing. I'm so happy for you. All right, guys. Thank you guys for your patience tonight. I almost said I wasn't going to come on tonight, even though I had the cases ready, just because my tummy was hurting so bad. And I'm like, they'll understand. They may have to watch the cat tree for a little bit, but they'll understand. I did not have time to make one. I'm sorry. I'm so super sorry. Mortimer Duke's always trying to talk me into more trouble. And I can't play one because you're not allowed to walk away when you're streaming other people's content. So I'm gonna have to just call it. I'm sorry. Oh, the best I could do is I could put Ricky on. I have a warrant to show cause docket. I have no idea what's on it. Haven't watched it yet. Jerry, I've got an appointment scheduled, honey, but they can't get me in for a while, so. I take it that's a yes. It's not edited. I don't even know what's on it, but I know I have it. It's the most recent. Mortimer Duke's begging now. All right. All right, so this was streamed let's see here. Not yesterday, but the day before. 5/22. So also Friday. It's Friday. Because we're now on Sunday at 1:30 in the morning, Mortimer Duke. Just letting you know.
Docket will be State of Kansas versus Charlie A. Mitchell. It's case number 2024 CR 511. Charlie Mitchell appears from the detention center Zoom location. Brett Sweeney on behalf of the state. James Watts as defense counsel. This matter comes before the court on a warrant to show cause which alleges probation violation, failing to contact the ISO upon being released from custody. And his current whereabouts were unknown at the time the warrant was submitted by Mr. Ketley on behalf of Community Corrections, who is present on this meeting with us. With that said, Mr. Watts, what are your client's intentions here?
Your Honor, my client would stipulate to the violation. He failed to report to court services upon his release, and would stipulate to the violations, or not court services, Community Corrections, and waive hearing in the matter.
Very well. Mr. Mitchell.
Yes, Your Honor.
You've heard the announcement made by your attorney. You understand that you're entitled to a due process hearing where the state would have the obligation of proving the allegation by a preponderance of the evidence. You can challenge the state's evidence, have the assistance of your lawyer, produce your own evidence at a hearing, confront the state's witnesses unless good cause was shown. And I need to point out to you, Mr. Mitchell, that among other lesser remedies, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand that?
Yes, Your Honor.
So do you waive a hearing in this case and stipulate and agree that you failed to contact Community Corrections upon being released from custody?
Yes, Your Honor.
All right, very well. Court finds that the defendant has knowingly waived his right to a hearing and stipulates and agrees that he committed the failure to report violation as alleged in the warrant to show cause. This is obviously a significant and material violation of the terms and condition of Mr. Mitchell's probation. I'll ask for recommendations regarding an appropriate sanction or penalty here. Mr. Sweeney, what are the state's recommendations in that regard?
Yes, Your Honor. So the state's recommendations are that Mr. Mitchell do a 5-day sanction, and that at that point that he transitioned to a residential bed over in Sedgwick County. Essentially, he's got a PV over in Sedgwick County where he just recently stipulated to, or I think was found to have violated his probation conditions over there. And they ordered him into residential, which is my understanding is kind of a halfway house. They're not allowed to leave except for certain activities, treatment, work, that sort of thing. And if they do take off, I think they may file escape charges over there. Quite frankly, I'm not sure on the basis of looking at our case alone whether that's necessarily deserved, but it is an option that they have over there that we don't have here. And so given that, I think, at least from the state's perspective, we're willing to recommend one final try over here with that alternative of residential custody over there in Sedgwick County after a service of 5 days. And then hopefully if the court would adopt that, I don't know if the court's inclined, but then a seamless transition into residential treatment over there, or not treatment, but residential housing over there.
I'll just note that Mr. Mitchell has been apparently locked up in our jail since April the 20th. He made a first appearance on that date. So he's been in custody on this matter for a considerable period of time. Why a 5-day sanction, Mr. Sweeney? Why not a more traditional dip sanction here?
I think he's already had a dip sanction. Mr. Ketley can correct me if I'm wrong, but I thought that he had. If he has not, I think I would change my recommendation to satisfy the dip sanction, so we may be in line with the graduated sanctions for Mr. Mitchell. But for whatever reason, I thought he had already had one. Maybe I'm incorrect.
Mr. Ketley, can you clarify that point?
I don't believe he's had a jail sanction, Your Honor.
All right, thank you, because I see he was just sentenced in January of this year. All right, Mr. Watts, in light of that discussion, what are your recommendations regarding an appropriate disposition here?
Your Honor, I think he's in line for a dip sanction, although frankly, having the 5 days of going directly to the halfway house or the residential unit over in Wichita might be frankly in Mr. Mitchell's best interests to go directly there. He has been in custody in our jail since, according to the return on service, the return on the warrant, April 17th. So at this point, yeah, well, about 5 weeks.
All right. Why can't he report on Memorial Day? I mean, I know they're open for business. They don't close entirely. Is there some administrative reason he can't report and fill his residential bed on Monday?
Yes, Your Honor. They only they only have intakes on certain days, and his intake was set on 5/27.
All right. Thank you. Mr. Mitchell.
Yes, Your Honor.
Do you have any statements that you wish to make in mitigation of punishment here?
No, but I have a bed open for me in Tree of Life. It's a sober house living there right now. That's where I plan to go if I got out today.
Sir, you fell out of the tree and hit every branch on the way down.
Checking in with probation and all that stuff, though, first.
Okay. It's the court's understanding that the recommendation of the attorneys is that he would go directly into some sort of Sedgwick County monitored residential program?
As soon as the bed opens.
Not a private program? Okay. All right. Thank you, Mr. Mitchell. The court has previously found a substantial material violation of the terms and conditions of Mr. Mitchell's probation. As a sanction for noncompliance, the court will order Mr. Mitchell to serve an additional 5-day sanction in the Butler County Jail with the idea of immediate then transfer to the residential bed waiting for him in Sedgwick County as part of the Sedgwick County program. Court notes the concern at this not counting as an appropriate DIP graduated sanction. But I think under the circumstances, it's in the best interest of this offender just to go right into that program after 5 days more are served. He will get jail time credit against his overall sentence for what he served on this. Mr. Mitchell, reporting is a fundamental part of any probationary program. I hope you realize that now and you won't miss any more appointments.
Yes, Your Honor.
Mr. Ketley, I don't perceive currently that there's a need for extension of probation. Would you agree?
I agree, Your Honor.
Very well. Any previously unsatisfied condition will need to be fulfilled by the defendant upon reinstatement, which will take over at this point after he serves his 5-day sanction and goes into the Sedgwick County residential program. No additional fees will be assessed in light of the defendant's most recent period of incarceration. I don't think he's got additional financial resources to pay it. Is there any clarification of the record necessary from your side here, Mr. Sweeney?
No, Your Honor, thank you.
Mr. Watts, anything further that you know of?
Don't believe so, Your Honor. Thank you.
Is there any further clarification needed for your purposes, Mr. Ketley?
No, Your Honor.
And last but not least, Mr. Mitchell, do you have any questions about what we've done here?
So there's a bed open already for me in treatment, or not treatment, residential already?
Sedgwick County's residential program, as I understand it, can do an intake on you in 5 days.
Okay.
So we're going to hold you in the Butler County Jail until you can go directly into that program.
Okay.
All right. So I'll remand the custody of Mr. Mitchell back to the jail until he can be transferred to the Sedgwick County residential program at the end of the service of this 5-day period. The Mitchell matter is currently in recess at this time. We'll move on to another matter. Do you have an additional case to take up on this docket, Mr. Watts?
I don't believe I do, Your Honor. This is it.
Then I think I can release you from the meeting at this time, sir.
Have a good weekend, Your Honor.
You too. Mr. DeHoyos, are you ready on one of your cases?
Either one, whoever shows up, I guess, in the detention center first.
Okay.
No, right.
This must be Travion Collins.
Yes, sir.
Yes, sir.
Court calls State of Kansas versus Travion Collins, case number 2024 CR 81. Mr. Collins appears from the Butler County Detention Center Zoom location.
What gave it away, Judge? Why would you assume that was Travion? The sirens are going.
Jorge DeHoyos appears as defense counsel. Brett Sweeney on behalf of the state of Kansas. This matter comes before the court at this time on a warrant to show cause alleging probation violation. Mr. Ketley's warrant would indicate that he failed to report for a scheduled office visit. Violation notice was sent to his last known address, instructing him to report. And again, he failed to report. What are your client's intention regarding this allegation, Mr. DeHoyos?
Judge, we intend to admit to the allegation and waive our rights in an evidentiary hearing on the same.
Very well. Mr. Collins, you've heard the announcement of your lawyer. You do have a right to a due process hearing where the state has the obligation of proving this allegation by a preponderance of the evidence. You can challenge the state's evidence, have your own evidence presented with the assistance of your lawyer, confront the state's witnesses unless good cause was shown. And Mr. Collins, I need to point out to you, among other lesser remedies that the court can consider, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes.
Do you intend to waive a formal hearing in this case and rather stipulate and agree that you committed the failure to report violation that Mr. Ketley has alleged?
Yes.
Very well. Court finds that Mr. Collins has knowingly waived his right to a hearing, that he has committed a substantial and material violation of the terms and conditions of his probation through his stipulation to his failure to report. We'll proceed to disposition on this. Mr. Sweeney, what are your recommendations regarding disposition here?
Yes, Your Honor. So it looks like he's already had a dip sanction. We were also here in December of last year where the court did find violations, but gave him no additional sanction, placed him back on probation. So he's had some chances in this case. He's also got substantial jail time credit. As of May the 15th, he had 256 days according to the Butler County Jail. So I show him at 262 days of jail time credit if my math's correct. He's got a 12-month underlying. I think revocation of probation in service of the sentence is appropriate in this case.
All right. Mr. DeHoyos, your recommendations regarding an appropriate disposition for your client.
Let me ask a quick question here. Treatment, when did you get arrested on this one again?
I got arrested back in March, like March 23rd or something.
So we were talking, you spent the last 60 days in custody. Is that right?
March, yes. I started in Cedar County.
Judge, the reason I'm asking my client that question is because I'm trying to figure out how much time would he have left. I think he's burned up his clock, and whatever is left of it is not more effective than the 60 days he's been sitting there. I guess my point here, Judge, is that we're burning up county resources that we don't need to by having him in custody when he's essentially time served. I can understand and appreciate that we should never cheapen a sentence of any kind, but for the purposes of rehabilitation or reform, 60 days in commitment at this point with what, 2 weeks, 3 weeks, maybe 4 weeks left of total possible jail time, it will take longer for them to process him and get him to peek him back than to have him actually serve a sentence. So, Judge, it's weird to ask for a modification that ends my client's case at this point and puts him into post-release, but that's exactly what I'm asking you for.
Mr. Sweeney, did your jail time computation take into account the days that Mr. DeHoyos is referring to here?
No, Your Honor. The dates that I was given by Mr. Reynolds, who's out at the jail, started at 4/22/26 when apparently he was booked into the Butler County Jail. Now, I'm not sure if there's additional Sedgwick County time that would need to be attached to that. I don't know. Mr. Collins may have more knowledge on that than I do.
I was, if I may speak, I was booked into Cedric County when they called me up for my warrants back in March 22nd or March 23rd when I was booked in to Cedric County on your guys' warrant and for them.
According to a parole chrono that I see in the system, he was already in jail and the Butler County hold was placed as of 3/31.
Counsel, Kansas case law recently has been very favorable to defendants regarding application of jail time credit while their case is pending. The warrant in this case was filed on March 26th. I'm wondering if he isn't just legally entitled to all jail time credit after this warrant was filed. He is waiting disposition from that point forward on this particular warrant. That stems back to March 26th. That's 5 days in March, 30 in April. We're 22 days into May. Well, not quite the 60 that I think Mr. DeHoyos would refer to. I mean, that's 57 more days. Should the court be inclined to grant him credit for that Sedgwick County hold time, he's up to 319 days of total sentence, which is more than 10 months of a controlling 12.
With a 20% good time removal.
Well, that's applied by Department of Corrections. This court isn't in any position to be able to determine whether he's entitled to good time credit for county jail time that he served. He could have been a total mess the entire time he was in the jail, or he could have been a model prisoner.
No,
Reality
you're
is, I
absolutely
don't
right.
have that information.
You're absolutely right, Judge. The reason I'm bringing it up is because let's assume for just a second he was entitled to his entire good time. He has spent 0.4 months longer than is necessary.
Mr. Ketley, would you, as the supervising officer in this case, care to weigh in on this discussion?
I think it's a little bit deep for me, Your Honor,
Okay.
on credit for time served.
Yeah, it's deep for all of us. Mr. Collins, are you on supervision anywhere else?
I'm actually on parole in Sedgwick County because I went to do my prison time in Sedgwick County last year, and when I got out released from prison in October, I got transported directly here from prison.
He is on parole, Your Honor.
And when I was in prison, y'all had issued that warrant. I had a detainer in prison for y'all for the whole 5 months that I was there.
Your Honor, to Mr. Collins' credit, it suddenly feels less weird for me to ask for what I'm asking for.
What is obvious to this court, Mr. Collins, is that you're not going to be successful on a Butler County probation. The court's going to do an outright revocation of your probation. You've had a previous dip sanction at least once, if not multiple times. It doesn't appear that there's any grounds for this court to believe you're going to be successful in any type of local supervision. This court has information before it that very well may lend itself to a finding that you are entitled to 319 days jail time credit, perhaps even more. Now, this court is inclined to grant the jail time credit that was discussed earlier, add that to the time that Mr. Sweeney had computed to create 319 days of accrued jail time credit and to modify the sentence to 319 days, which means essentially you completed the sentence in this case, quite unsuccessfully, I might add, Mr. Collins. But what that then does is essentially pass this case over to post-release supervision. This is a unique situation before us in that you've essentially completed your sentence. As far as I know, do you have a parole hold on you right now,
No.
Mr. Collins?
No, sir. My parole
Well,
hold.
I want to get you on to post-release supervision in this case because there is a statutory post-release supervision period in this case, presumably 12 months, that need to be served in this case. And the court has no intention of relieving the defendant from his 12-month post-release supervision requirement. Further, anything that's already owed in this case will need to be sent to collections if it hasn't already. It's still due and owing. I'm not going to add any additional fees because of Mr. Collins' long-term incarceration periods, but anything previously assessed remains to be paid. And I'm going to just enter in order that if that's not paid by June 1st, that it's all to be sent to collections if it hasn't already. All right, so Mr. Ketley, the mechanics of getting him on to state parole, essentially post-release supervision period starting. Now he's already on reporting state parole. What needs to happen to make sure that he's also on this case?
I think that once the journal entry is completed, it could be sent to parole, and I think they would pick him up at that point in time.
How would that journal entry get to state parole?
It normally goes through Department of Corrections, but if I know that it's completed, then I can send it to the parole officer.
Okay. Okay, now I would thank you for your service to the court in doing so. And you don't have any other holds on you right now, Mr. Collins?
No, sir.
Just this case?
Just this case.
Do you have a reporting date to your state parole officer?
I would report as soon as I leave, whenever I would leave here. I would end up having to make my way back to Wichita and report. but before 5. Because her office hours are 8. Her office hours are from 8 to 5.
It's just that the court considers the possibility of you getting processed out and then somehow getting yourself transported to Wichita for a state parole meeting before 5 o'clock to be
And if not,
almost miraculous circumstances.
I don't believe so. I'll be able to call my mom and get in contact with my sister to come get me like I did last time I got released.
Well,
but if I don't get there,
logistically, that seems problematic, but if you can pull it off, that is exactly what this court would want.
okay.
Okay. Mr. Collins, if you don't have other holds on, I'm going to order you released because your time has been flattened in this case, but we do have a 12-month post-release supervision period
Yes,
that you
sir.
need to complete. And that money's hanging out there for you to pay until it's taken care of.
Yes, sir.
So I wish you could have been more successful on this program and you wouldn't have had to serve so much time on it. But we are where we are. Good luck on state parole. I hope there are no violations and that you successfully complete all your state parole post-release supervision programming.
Yes, sir.
All right. And then I hope that that call can be made to mother here pretty quickly.
Okay.
So Mr. Collins, keep in mind, if you get processed and released after 5, then you're reporting first moment
Monday.
that office is open.
Monday
And I
morning.
need you to leave a voicemail for your probation officer if you get out, or
Okay.
parole officer if you get out. I need them to know you're contacting them.
Okay.
Thank you, sir.
And Mr. Collins, I don't know if they're going to be open on Monday. It's Memorial Day.
Okay.
So you may be first thing Tuesday morning.
Yes, sir.
Okay. All right. Do any of the professionals on this meeting have anything else to address the court regarding Travion Collins?
No, Your Honor.
No, Your Honor.
Does not appear to be any other responses. Thank you all for your input to the court. And again, good luck to you, Mr. Collins.
Thank you.
All right. There's nothing further. The Collins matter will be in recess. We'll move on to another matter.
That was my last case, Your Honor. Am I free to go?
You are, Mr. Ketley, and thank you for your assistance.
Thank you.
Oh, it's Tony on April. Okay.
April Lyman.
Yes.
This is State of Kansas versus April Lynn Lyman, case number 2024 CR 396. April Lyman appears from the Butler County Jail Zoom location. Jorge De Hoyos appears as defense counsel. Brett Sweeney on behalf of the state of Kansas. Also note the presence of Tony Bauer from the Court Services Department here in Butler County. This matter comes before the court at this time for further proceedings regarding a warrant to show cause alleging probation violation. Summarized, a failure to make payments, missing appointments, not maintaining employment, testing positive for methamphetamine and amphetamine. What are your client's intentions regarding these allegations, Mr. De Hoyos?
Judge, we're not going to contest the allegations in the warrant. We're going to waive right to evidentiary hearing on the same and ask that we move forward with disposition.
Very well. Ms. Lyman, you've heard your attorney's announcement that you intend to now waive a hearing.
Yes.
You do understand that you're entitled to a due process hearing where the state would have the obligation of proving these allegations by preponderance of the evidence. You can present your own evidence at such a hearing, challenge the state's evidence, confront the state's witnesses unless good cause is shown, and have the assistance of your lawyer. Also, I need to point out to you that among other lesser remedies, the court could consider an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
Do you also understand that you have a 12-month county jail sentence potentially in this case?
Yes.
So you're waiving a hearing and stipulating and agreeing that you committed these violations that the court outlined earlier?
Yes, Your Honor.
All right, very well. Court finds that April Lyman has knowingly waived her right to a hearing, stipulates and agrees that she committed the violations as alleged in the warrant to show cause. These are substantial and material violations of the terms and condition of April Lyman's probation. We'll proceed to disposition at this time, and I'll ask Mr. Sweeney the state's recommendations regarding an appropriate disposition for her.
Yes, Your Honor. Thank you. So, Ms. Lyman has already had a prior a prior sanction by the court, and then also given the allegations that have now been stipulated to in the request for revocation of probation, it's clear to the state at least that she's not amenable to probation. So we're asking for revocation. However, for Ms. Lyman's stipulation, we have agreed to recommend rather a modification of the 12-month jail sentence to a 6-month jail sentence, essentially asking for modification to concurrent. Essentially, these two misdemeanors were respectively run consecutively initially. We believe she's got a substantial amount of jail time credit, but there's still going to be a fair bit for her left to serve on 180 day if the court would adopt those recommendations.
Based on current figures before you, Mr. Sweeney, how much accrued jail time credit does she have?
As of May 15th, Mr. Reynolds indicates that she had 132 days, so I'm looking at 139 days, if that's correct.
Okay. I would think that the jail's computation is probably correct. All right, thank you for that information. Mr. De Hoyos, your recommendations regarding an appropriate disposition here.
So Judge, if my math is right, that leaves about 41 days left in a 6-month sentence, correct? I may be wrong about that, but is that right?
I think your math is correct.
That being said, hear me out. I know that there's more to the misalignment story than just this case alone, and also how this case resolved. Those two counts, one being possession of marijuana, that other one being possession of paraphernalia. I have yet to see many cases in which you have one without the other. So I've always surprised when things are ran consecutive in the nature of those kinds of charges. That being said, what's going to help Ms. Lyman is what she's pursuing with sobriety, and she has done an evaluation just recently with the Substance Abuse Center of Kansas, who has recommended an outpatient treatment. They have opportunities for her both in Augusta and in El Dorado. And actually, she resides in Eureka, so I think El Dorado would be the closest position. And Ms. Lyman, correct me if I'm wrong about anything here, please. But Judge, I just don't see the benefit of 41 days of preventing her from going to treatment for 41 days. That's essentially all we'd be doing. I'm not trying to, again, minimize the importance of a sentence or anything of the nature, but I think that she's been in custody now about 41 days, and I would seek that she just get to treatment, get sober, and help us all out by doing the same.
Ms. Lyman, at this time, the court will address you personally and ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court.
No, Your Honor.
Ms. Lyman, before the court announces its dispositional orders in this case, this was a case that was plea bargained, presumably favorably to you, which resulted in convictions of 2 misdemeanors, 6 months apiece, run consecutively for a 12-month controlling sentence. Now, the state has recommended somewhat favorably to you that the court essentially, in essence, run these concurrently for you just to serve the remaining balance of a 6-month sentence. Your attorney has made a suggestion here that perhaps a treatment program would do more in the long run to facilitate your rehabilitation ultimately, but the court disagrees for this reason. Ms. Lyman, you were ordered as part of your original sentencing to get a substance abuse evaluation and abide by the recommendations. If you really wanted to pursue treatment, that was the goal of the court at that time. Further information in this file would indicate that when you did get an evaluation, you wouldn't admit the prior meth use, and therefore you didn't get into a treatment program and successfully complete it, which is somewhat frustrating. What a substance abuse evaluation is intended to do is to address whatever substance abuse problems that you've had in the past or are currently experiencing. But I think you have to be completely honest and have resolve in your commitment to seek treatment and successfully complete it. And I don't see that over the course of this case, you have ever taken that approach up till now. Now you say treatment is what you want to do in lieu of jail time. I think you've had your opportunities to seek a treatment alternative, but you haven't decided to go and follow through with those opportunities. So the court will at this time do an outright revocation of probation in this case, finding that April Lyman is not amenable to probation and to successfully complete it. Will order her to serve the remaining balance of a sentence in this case. However, based on the state's recommendation and essentially the agreement that was reached in this case, the court will modify the sentence to a period of 180 days. Order the defendant to serve the remaining 41 days as the court grants her 139 days of jail time credit. That's about a month and a half more, Ms. Lyman. But under the circumstances, you're coming out of this case favorably. It could have been much, much longer. And then it would be the court's hope that if you really do have the resolve toward treatment, that you enter a treatment program on your own at the conclusion of satisfaction of the jail time in this case to avoid ever coming back into the system. Any outstanding balances in this case need to be paid in full by June 1. If they're not paid in full by June 1, the court authorizes that any remaining balance be sent to collections. If it's already been sent to collections, so be it, but June 1 to pay the remaining balance if the matters have not been previously sent to collections. I'm not going to assess any additional fees under the circumstances given Ms. Lyman's incarceration status. Mr. Sweeney, are you aware of anything else that the court needs to address on April Lyman at this time?
No, Your Honor, thank you.
Mr. De Hoyos, anything further currently?
No, Your Honor, thank you.
Ms. Lyman, you have any questions about the court's orders?
No, Your Honor.
I will remand your custody back to the Butler County Jail to serve 41 more days before being released, as the case will have essentially been flattened at that time and all of the sentence has been served.
Thank you, Your Honor.
Right. There's nothing further then. The Lyman matter is in recess. Mr. Sweeney, it's the court's understanding that that would complete the cases that were scheduled on this docket. Do you agree?
I do agree.
Very well, then I'll offer everyone. I hope you have a good weekend from here. That will conclude the docket. Court is in recess, and the meeting may be ended for all.
I honestly think that they should do that more often. I wish I was as sly as you seem to think I am. I'm gonna, yeah, no, my tummy hurts. My tummy really hurts. I'm gonna go now. You can talk me into trouble on another day. If I stay on here, oh my gosh, you need to fight it out with the rest, because they're gonna myrtleize you. I love you guys. Oh yeah, I don't think April's gonna be able to sleep for a while. My tummy's killing me. Thank you guys so much. I love you all. Nah, don't let them fool you. Mom, what are you doing up so late? I love you. Y'all can go play in the Discord. Be safe, be well, Sleep sweet and much love.